For those of you that don't know who I am, my name's Paul Jant. We are here thanks to Professional Partners Education, Paul Chadwick, Profit Master Global Outsourcing, iKeep, and Lloyd's Auctioneer. So they're our great supporters and our sponsors, which is fantastic. A massive shout out to Danielle Morrison as well. I think Danielle is online, but it's always important that I say thank you to Danny, because it's her invites that get you guys here. And she's a part of our team at Hall Chadwick and PPE. So you've been invited because you're a close friend of Hall Chadwick or Professional Partners Education. And we're here to continue the chat on family law. So what we're going to do, this in a couple of stages, because I know for those of you that maybe missed out on the April Lunch and Learn workshop, we went into a number of different topics. Now, just to give you a bit of an idea. So we went through prenups, we went through commercial mediation benefits, we went through loans to parents, and how does that looked at in terms of separation. We went through how to determine an asset pool, the role of a BFA, consent orders. Now, one of the things we did miss out on was how to value a business. And I've asked Tuskeen Jacobs to come back from RCR to come back and take us through exactly how that works. So I know last time we mentioned there was about 4 to 5 different ways to do that. So first of all, Tuskeen Jacobs, how are you? Welcome back.
I'm very well, thank you. Thank you for having me.
It's our pleasure. It's great to have you back. Now, let's get into this, because we missed out on this one last month, and we've got about 20 minutes, and then we've got another guest coming on as well. We've got Bridget O'Kane joining us as well. So talking about valuation of businesses, let's go through this. So in the event of a marriage breakdown, what is the process? Because I believe there's 4 to 5 different ways to value a business.
There is 4 to 5 different ways that accountants will value a business, but the outset for us as family lawyers is disclosure. It's like the big mantra, disclosure. It's an ongoing obligation that parties have. So the starting point, if you are going through a separation or if you're advising your client, is financial statements, bank statements, income tax returns, trust deeds, all of those financial documents. The last 3 years is the starting point. We collate them and we then send them off to sometimes our own accountant to have a look at, to get an idea of what the business may be worth, because it's not going to surprise you. The person that's holding the business is going to say it's worth bugger all, and the other party is going to go, this is a cash cow. So they're going to assign a high value to it. So sometimes we can reach an agreement on the valuation, but typically, because of the dispute between the parties, we have to, under the family law rules, engage what's known as a single expert valuer. So we engage a forensic accountant. That is a process where 3 names are put forward by one party. The other party nominates their choice, and both parties then pay half the costs of that valuation expert to undertake the valuation. The process then is actually determined by the valuer. So depending on the nature of the business. So for example, if you have a minority interest in a company, then the valuer may use what's known as a capitalization of future maintainable earnings. So that's typically not used for shares in private companies in family law purposes. And I guess we're looking at factors like, can the minority shareholder influence the other shareholders? And if not, then we'll go down that road. The other process that is used is known as the net present value. That's when valuers are having regard to the future cash flow stream that flows from a project. And it's usually done when a business has a finite life. So there's a short time frame where this business is going to kick off. So the valuer will use that process. The most common used valuation process is that the capitalization of future maintainable earnings. That's where you've got a business that's been trading for some time. So we've got some nice, 3, 4, 5 years of financial records to look at. And we're going to be looking at the profits that are going to flow moving forward. So the valuer is going to adopt typically a dual approach where they look at the capitalizations of earnings. And then they'll also look at the adjusted book value for the assets and the liabilities surplus to the operations of that business. It does require sometimes a very contentious issue, which is where the valuer will assign a multiple, and that multiple may be quite high. And so typically the business owner will go, no, that's the wrong multiple you use, because now you've assigned my business with this multiple, meaning it's got this value, and I want you to have a look at that. In very limited circumstances under the family law rules, if we're unhappy with the valuation, we get what's known as a shadow expert. And so if I'm unhappy with the valuation you've done for me, for my client, I'll get Joe Blow. He'll come in, he'll have a look at the valuation, and he might assign a different multiple to it. No surprise, first value will go, no, I'm right. Second value will go, no, I'm right. So the rules allow for what's known as a hot tub situation. So the two experts basically duel it out to see who's right. Again, no surprise, usually both valuers are going to stick to their guns, and it's then up to the judge to determine which valuer got it right, for want of a better word. The fourth and final valuation process we see is a net asset backing valuation. And that's used typically where you've got entities and they're not making profits, but they may do so in the future. So I'm trying to think of an example, and on the spot, I actually can't think of one, but it'll come to me in a minute. But you're probably looking, as I said, at the capitalisation of future maintainable earnings as your most appropriate valuation methodology. The other thing I just want to touch on quite briefly is inter-entity loans. So it's not uncommon where you've got a business and you take some money out to pay for whatever it is, school fees, whatever. We don't forget about that when we're looking at the valuation of a company. So if it's excluded in the valuation by the valuer, it's important to realise that it's then put on the balance sheet of the husband and wife. So if the hubby owes money to the company, for example, or the wife or shareholder or director, I'll use no politically correct language, then we've got to remember to take that loan account as either an asset or liability of the parties when we're looking at the balance sheet of the parties.
Okay. Is there one that would be used more than others, or it just depends on how it all flows through?
No, look, it really does depend. In my experience, it is that capitalisation of future maintainable earnings, because most businesses will continue to trade because one of the parties, it's their livelihood, it's their baby, so they want to continue to trade. It's very rare that in the midst of a property law settlement that we go, let's wind up everything. Businesses generate income, it's the livelihood for many families. So yeah, the reality is that in most cases, parties are going to continue to trade in that entity, however they've structured it. It might mean that we have to, remove a wife or a husband or as a shareholder director, and that's all part of the process as family law solicitors. Yep. Sorry, the other thing I just also want to mention is for the non-accountants, if you are looking at a transferring of property in the context of family law disputes, because we didn't touch upon this last week, there is the rollover exemption relief. So oftentimes we have banks that say to clients, go to see your solicitor because you'll get paid. If you transfer an asset, there's stamp duty. Stamp duty, if you're doing your property settlement, as everyone should, pursuant to a consent order or a BFA, which we touched upon last month, that will trigger the stamp duty exemption and that CGT rollover relief as well.
Okay. Yeah, well summarised. So just to again, if you can just go through very quickly the four. I think you went through four. What were they? There?
So we're looking at the capitalisation of future maintainable dividends. Okay, not commonly used. We're looking at a net present value, again, not commonly used. Most commonly used is the capitalisation of future maintainable earnings. And then the fourth and final is the net asset backing. Beautiful. And that you see that occasionally.
Yep, fantastic. Look, to everyone online, because I know this was a bit of a quick little recap before we get into talking to Bridget O'Kane. So if you've got any questions, we're happy to take any questions you've got. I know if you want to go back as well, please, these go up online on our PPE TV Plus site anyway on our YouTube channel. So if you want to go back and have a look at that and then look at what Tuskeen's saying as well, you're more than welcome to do that as well. And again, Tuskeen, just so everyone knows where they can find you at RCR. Where do they find you?
Rostron Carlyle Rojas or RCR Lawyers.
Yes, exactly.
We can
Polly,
Brisbane,
don't leave out
Sydney,
Polly.
Melbourne, all over Australia. You can get us.
Yeah, beautiful. So check her out on whether it's LinkedIn or wherever. Just and then again, if you need more advice, a little bit deeper on these elements, please reach out to Tuskeen. So let me check. Any questions? No. Look, Tuskeen will still be online anyway. So if you do any questions and we can come back, there's no doubt we can do that. So thank you very much, Tuskeen, for coming back and sharing that little bit with us. And it's a funny thing that you mentioned as well, Tuskeen, that you mentioned obligations before. So this is something that we're going to it's a nice little segue, because we weren't going to talk about that, but you talked about you spoke about disclosures, and that was a really important topic right at the front there. And we're going to just sort of segue into that now with our next presenter and our next guest, which is Bridget O'Kane. So Bridget O'Kane is from SLF Lawyers. And we're going to just talk about three key things here. We're going to talk about navigating your clients and their solicitors through, let's say, some family law matters and proceedings. We're going to talk about disclosure. So Tuskeen touched on that before. We're going to talk about disclosure obligations with regards to tax advice and financial planning. Again, Tuskeen touched on that. And then we're going to go into, again, obligations. And I think it can get a little bit tricky when, you guys as the accountants may have acted for both parties in the past. So we're going to do a quick little switch over here. So thanks, Tuskeen. I don't think there's any questions. We'll say bye to you, but stay online, and welcome. Hello. Bridget O'Kane, how are you?
Hi, I'm really well, thank you. Good afternoon, everyone, and thank you, Tuskeen and Paul, for the introduction. Today's presentation is really just to be a basic guide on how to work with your client solicitors in family law matters to get them the best result, because at the end of the day, that's what we want. And if we can save costs by working together well, then we should be. The breakdown of a relationship and the resulting division of finances is a really stressful time for clients, and accountants can play a huge role in minimising the cost and stress for their clients. A good accountant-solicitor relationship is incredibly helpful to us and to the client, and will lead to better outcomes for the client. I'm not going to be talking about client stay where they have a house and some super and maybe some savings. This is more directed at big money matters where there's often actually it's not big money matters. They might not have much money, but they have a really complicated corporate structure that often has to be untangled to effectively get the clients out. So this is designed to help these clients and how we can best work together. So the first thing I'd recommend is, if the family lawyer hasn't reached out to you, reach out to them, get your client's consent, give them a call. I had a call from an accountant in Ballarat that's acting for one of my clients last week. It was super helpful. We had a chat. The husband owns a business. He was helping me to understand a bit about the business. There were some cash issues and we spoke about that. And I've reached out to him a couple of times since. And I think it's really helping my client. And it's been really good to hear from the accountant in relation to what he thinks is necessary to get things moving. If there's a complicated corporate structure, provide the structure diagram straight away, and explain to the solicitor how the entities interact. I mean, we can always work it out, but sometimes the quickest and the easiest option is to have that discussion and to get the entity. Usually the accountant will already have it, so there's no point recreating the wheel effectively. Yeah. If there's significant liabilities, including tax liabilities, tax losses and carried forward losses, let the solicitors know straight away. That really helps us develop the asset pool, as Tuskeen spoke about, which is really the first step in resolving our clients' family law matters. Sometimes the clients don't provide the entire picture, or in a lot of cases, they don't understand it. And whilst some clients are really good, a lot really rely on their accountants, as you'd know, and when we ask the questions, we don't get many answers. So that's absolutely really helpful for us to get the first steps underway and have an understanding of what there is to divide.
Is there a bit of a, and I'm personally, I've been through it as well. So and I think most accountants certainly as I've spoken to them and been in the industry for as long as I have, I know a lot of firms probably find out about the separation before the partner finds out about the separation.
Absolutely.
So is there a bit of a template where, you know, accountants sort of watching this can go, right, what's a starting platform? What do I need to start asking and gather, or would they already have a framework in their mind?
So establishing the asset pool for clients is really the first step, and often a really helpful step. Say if there's a family business and might have a number of different trust entities or corporate entities. So that's in family law, we have a 4-step or 4 to 5 step process depending on the matter. I think Tuskeen spoke a bit about that last month, didn't she? So just tell me if I'm you know, going over things she's already spoken about. So we give advice in relation to the steps, which are contributions and future needs, and then just and equity. But I mean, if the accountant's aware, the accountant can certainly help with the asset pool, because in most circumstances, they have a better understanding than potentially the client.
Yes.
The other thing they can help to provide is evidence for contributions. So, for example, if the parties came in, or one of the parties came into the relationship with a property, if they have evidence of that, if there was gifts from parents or a redundancy that they're aware of, properties were sold and there was a capital gains liability. Often, as accountants, you guys have a really good knowledge, and a lot about family law is providing the evidence of that. So, if you can assist your clients to locate that and provide it to them, that is super helpful. Or even directly to the family lawyer,
Yes.
CCing the client. So that's really, I mean, if the more accountants can help solicitors, the better, especially with clients that potentially, if they're older and don't have, you know, not great with technology, or they're not commercially savvy.
Yeah, it's very true. And 9 times out of 10, you know, you're right. The firm is going to have more of an idea of the assets, and even as business owners, we'd still turn to our accountant and say, a bit like what Tuskeen mentioned before, well, how am I going to value my business here? It's a major part of my asset pool. So yeah, it's a really important one, isn't it, to engage with the firm, or have the firm engage with the clients as soon as possible, be proactive about it. Yeah,
absolutely. And especially because, and the other thing, clients sometimes think that their assets are worth significantly more than they are. Having those tough conversations early on can save them a lot of time and money. If say they think the business is worth $10 million, or their husband, they think or the wife's business is worth $10 million, they might be able to have a look at it and go, I can't see in any world, based on the financials, that this business would be worth 100 million or 10 million or 100 million or whatever it is.
Yes.
If there is any due dates for payments of liabilities, let us know. We may need to get agreement from the other side solicitors, or, you know, in really significant and serious circumstances, do an urgent application for the court. If there are payments in place with the ATO, let us know about those. And if there's any interrelated family loans, that's all excellent information.
So going back to a topic of what Tuskeen mentioned as well, in terms of disclosure, and those disclosure obligations, tax advice, financial planning, how do we navigate through that?
Well, normally there's a couple of ways you can do it. I mean, you can, if you know that there's sort of significant issues and you've got the documents, provide them to the solicitor. Otherwise, I just say pick up the phone and say, look, we're aware of these things. What do you want? What do you need? How can we help, really? Sometimes I find a quick phone conversation often is the easiest way to tackle these. Because the great thing about the solicitor accountant relationship is you're on the same side, so you can have those chats and work out what you need.
And I suppose that's where the next stage of this gets a little bit tricky, isn't it? When the accountant has acted for both parties in the past. So how does that work?
Absolutely. Well, I can go down to that. So in my view, I don't think you can continue if they're in a family law situation. I don't think you can continue to act for both parties. I think it creates a conflict. And what might be advantageous to one client in relation to a tax outcome might be really detrimental to the other. So what I found is accountants often pick one party and then maybe help the other party find someone else,
right,
to look after. I think in long marriages, the accountant might have acted for both parties for 20 years, and it's a real issue when you've got bonds with both parties. I think what you do need to do in that circumstance is the person who you're no longer acting for will probably ask you for documents, which obviously you need to provide. It's probably giving that ongoing tax advice or financial planning advice that leads to the conflict. So yes, you might need to explain to them what happened in the past with the financials or the tax returns, but it's going forward whether or not you can continue acting. And in my experience, the accountant tends to pick say if the husband owns the business, the person who owns the business, because that's where the work is.
Well,
and
right. Yeah.
And you can't criticize anyone. That's life, isn't it?
I was about to say that's usually where they would go, where the work is, because that's where you want to retain and you want to act on behalf of your client as best you can, whether that's the husband or the wife.
And look, and in some cases, both parties have businesses, and that becomes more complicated. But realistically, the bigger client will usually stay with the accountant, and I think the clients and the lawyers always accept that.
Yeah, fair call.
Yeah.
Now, before we touch on anything more, guys, girls, if you've got anything in terms of questions to our audience, we've got some questions coming through now. So comments, questions, case studies. We're happy for anyone to throw anything into the Q&A right now or into the chat. Here's one here from DMAC. Welcome, mate. Good to see you online again. PJ, can an accountant act for both parties under the instructions of both solicitors? No advice given, only acting on instructions or advice is sought, then advice provided to both solicitors.
I'd proceed with caution. It's not the solicitor's consent you need, it's the client's. Look, I've had parties where, it's very amicable. There's not much to it, and they are happy to consent for the accountant acting for both parties. I think when you'd really have to think about it is if there's advice that if the parties' interests really conflict. And that's when you have to say, I don't think I can act for you both, because that's where the risk is. For example, there's CGT on one property and it's $800,000, and you haven't told one party, and it's a big advantage to the other. And then, if that advice creates a disadvantage, then that's but if you, for example, give that advice in an email to both parties, just as basic tax advice, then I can't see any conflict. I think if you're giving strategic advice.
Okay.
Yeah.
Tuskeen, if you're still there as well, we might ask you to come back, and if you've got any thoughts and opinions as well, you're more than welcome to jump on in. There we go. So if you've got any thoughts and opinions on any of that, please help our audience.
No, look, I think I agree with everything you've just said there, Bridget, in terms of, in my experience, accountants do tend to retain or continue to act for the business owner. And again, that makes sense. I had a matter very, very recently where I'm acting for the wife. It's a business that's run by the husband, but she has been, for want of a better word, a bookkeeper. And for her own personal tax returns, the accountant has said he doesn't wish to act, and my client got very upset about that. And I had to say, look, that's the reality, and here's a list of accountants that can act for you. So it's a shame, but that's just a practicality, I guess, of going through a separation.
Yeah, that's a fair call, and that's the great part about, we do have a lot of accounting firms out there, which is always great. And I know that at the end of the day, you've got a relationship there, although there's a lot of involved in different CPA discussion groups, and there's always friendly firms that will always refer someone on as well, because it's in their best interest to look after the spouse, whether it be the husband or wife.
And I think especially if there's a good relationship between the accountants, you may not lose that knowledge, because one accountant can call the other if they've got questions or concerns about anything that's happened previously. So, but 100%. I think the reality is personal income tax returns, not rocket science. So it's it's
No
I mean,
disrespect to
no
our audience.
disrespect to anybody. So it's something that can be picked up by another accountant relatively easily.
Yes.
For the next financial year.
Yeah.
Does anyone have any further questions on that issue?
So please drop them in, or any chats, or anything you'd like to drop in there.
So the next part of the talk is the next question is disclosure obligations, tax advice, and financial planning. And I've broken that down into 3 steps in resolving family law matters. And I think these really apply even in litigation, although I'm really speaking to a mediation situation in this next bit. So we've spoken about disclosure and ascertaining the asset pool. I'm sure all of you have received really lengthy solicitor letters that your clients have sent you and said, I don't want to have to do this. This is ridiculous. They're asking for too much. This is my private information and I'm not doing it. They will hear from their solicitors that it's a very clear obligation that they have to the court, and they have to do it. So we spend a lot of time explaining to clients why they have to provide their disclosure. And look, I understand providing all your bank accounts is a difficult thing to do. It's personal information, but the reality is once you marry someone or you're in a de facto relationship with someone, you don't have that type of privacy anymore when the relationship dissolves. So we spend a lot of time dealing with the issue of disclosure, and it can really prevent a matter from progressing. The client might say, I've got nothing to hide, I just don't want to do it. And I always say to my client, well, there's nothing more suspicious than someone refusing to provide something. So if you want to, the easiest way is to disclose and move on. And then we get the fun job of reviewing in minutiae bank statements and tax returns and all of those different documents. But I think accountants are often the first port of call with their request for disclosure. I find that some clients, even though they've signed all these documents, just say they don't have copies of them, or don't understand, or don't know. So often we deal with accountants, and that I find is one of the easiest ways of dealing with this disclosure. The ones that we especially need from accountants are trust deeds, constitution, loan docs, resolutions, and the financials. And as Tuskeen said, the starting point is usually 3 years. Although if there's an event that the case kind of turns on that happened previous to that, we might seek those documents as well. So we might be asking for 5 years or 7. Often if it's over 7, those documents don't exist anymore. But if you are asked if you have copies of documents over a certain number of years, there is usually a reason. And if you do have them and you can produce them, that is often incredibly helpful. Helping clients produce these documents quickly and in formats that are easily accessible, like OneDrive. Like yesterday, I had a solicitor from the other side send me 15 different emails with their clients' disclosure, and it drove me mad. So if one of your assistants is able to put things into a link, and have them organized, that is really helpful, and it will save your client time and money on legal fees. If a client owns a family business, I often ask the accountant that has acted for the business to prepare an indicative valuation. Obviously, it's slightly different to the valuations that Tuskeen's talked about because they're usually joint. This is normally just an interim measure that allows negotiations, if possible, to start. So if the accountant can go, I think it's worth 300,000, we can propose that to the other side, and we can either negotiate on that basis or proceed to a formal valuation. So I find that saves time and delay. And if the accountant can produce that for us, we might be able to get to a negotiated settlement. Now, for all the accountants worried about, how that they are able to do that, and obviously they're only acting for one side, it's whether or not the parties accept it. So 9 times out of 10, the other side will say, I don't agree with that valuation, and we proceed to a joint valuation. But I find it really helpful, and often the clients do too. So it's not something to be fearful of. I mean, if you can't do it or you feel uncomfortable doing it, then obviously that's okay. But if it's something that you can do, it is a really useful interim step, at least at the very start of a matter. In the event that the business is valued by a joint valuer, I often ask the accountant to review the valuation and provide feedback, which we can use to ask the valuer questions or in cross-examination. If we don't do a shadow valuation. But even when we're still under the rules, each party is allowed to ask the valuer questions in a certain amount of time. So that can often be really helpful. And sometimes the valuer just gets basic information wrong. So it's good to put that up front, and accountants are really invaluable at giving us that information. And if, for instance, you're acting for the other party who hasn't acted for the business, that's still something that is really useful and can be done, because obviously as accountants, you're much better at reviewing financial documents than lawyers. So even if you haven't had that ongoing relationship with the business, there's still a real value add for that. And so, and often sometimes lawyers don't ask you to do that. It might be something that you say to your client, look, I can help you with this if your lawyer thinks it's appropriate. So, talking to the client about how you can value add in their family law matters, I think is really helpful too.
Yep.
The next step is negotiations. So to participate in a mediation, a client needs to be aware of any tax implications for proposed settlement, including CGT. If there's any implications for transferring an asset, say from one entity to the individual. And really they have to have it. And if there's any nasties in what would be a proposed settlement. So often, we should go to mediation with an idea of what we want and what the framework of the settlement would look like. So for example, the investment property goes to the husband, the wife keeps the house, the business is transferred to the wife, and some shares that were, some were owned by the wife transferred to the husband. There's obviously going to be tax implications in a number of those transfers. So going into the mediation, the client needs to understand what the implications for the proposed settlement are, and have that in written advice. So we've got it, they've got it. I had a matter that was, I think it was about a $20 million matter, and there were a number of properties owned in Sorrento and Portsea, and the CGT calculations for those, when you've got properties worth millions that have been owned for say 20 years, CGT is something that was a massive issue. And so we actually had the husband's accountant prepare his CGT calculations, which we then had checked by our client's accountant. And that was a pretty sensible way of doing that, because the mediation just could not have progressed in that instance if we didn't have that information. The same with business. If your client's wants to take over the business, they need to know about any, like real serious liabilities. If there's tax liabilities, if the money owed to the ATO, if there's contingent liabilities, all of that is really important prior to the mediation. Obviously, assisting and reviewing the asset pool is part of the negotiation. So accountants can certainly help with that. So it might be that they have a look at the asset pool prior to the mediation, ensure that there's no liabilities missing, or if last month's tax debt hasn't been included, all that is something that they can help with. And then during the mediation, I find it incredibly helpful to have an accountant available via phone, or at the mediation if it's appropriate, so that they can give further advice. So for instance, often we go into a mediation where we've got a plan, we've talked about our client, and then as a result of the negotiations, the plan's completely thrown out the window. We're no longer retaining the home, we're retaining the investment property. We're now not having the business, it's been transferred. I mean, it's normally not that, it doesn't normally change that much, but it can. So if we can have, and I know it's really stressful for accountants giving advice on the fly because it has consequences, but it is I always find if I've spoken to the accountant a couple of days before and asked them to be available, and that they can provide us that updated information, it leads to a better outcome, and an outcome that we can finalise, as opposed to waiting for that information. And the thing with mediations or any kind of negotiations that last all the day, it's better to get a settlement on the day, whether it be by heads of agreement or by consent orders, because often when parties go away, they get cold feet and you lose the whole thing. So being available for a client on the day can get a settlement over the line. So they know what they're looking at, and they can make that decision with their eyes open to say if it's, they know that they're taking on an ATO liability of 200,000, but the accountant thinks they might be able to negotiate it down to 80,000, but the worst case is 200. They at least are aware of that and can factor that in. And I mean, you like us can never give definitives, but that range can often be really helpful.
Yeah, brilliant.
And then the last one is drafting settlement documents. My preference is always to send draft orders or financial agreements to the accountants to seek comments and review to ensure that the proposed orders don't create unknown tax implications. The aim of any settlement should be to be as tax effective as possible. And sometimes the wording that we as lawyers think is the most appropriate wording can actually create tax implications for our clients. So it's really important that if possible, the accountants can have a look at that and tell us that what we're proposing doesn't create a liability that's unforeseen by our clients. The other thing that accountants do is after the audit's made, they're likely to do the transfer documents that affect the orders, the meaning of the orders. So transfer the company, or transfer the directors or the shareholders, or do the deed of amendment to the trust. And providing the financials in relation to settlement proceeds. So my view is a really good, accountants can provide, amazing assistance to, and my preference is a really hands-on approach where we're all working together and in contact, if possible, from the start. So things, tax liabilities don't become an issue on the day before mediation.
Yep. Well said. Well said. Now, if you've got any questions, again, we're going to wrap up in a couple of minutes. So if you've got any questions, please throw them into the Q&A and we'll keep an eye out for them. But otherwise, look, great information again, both from Tuskeen and from Bridget. So we'll open it up for another 20 seconds or so. Quickly type away if you've got something that you want to ask, share, whatever it may be. But otherwise, Bridget, just so everyone knows, SLF, where can they find you?
You can find us in Melbourne, Brisbane, Sydney, and the Gold Coast. And we are online with LinkedIn, and we've got a website. So feel free to contact us if you've got any questions or concerns. I'm sorry, I should say we're not just family law. We do insolvency, bankruptcy, commercial in all those jurisdictions.
Brilliant, 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 brilliant.
Great.
Well, it looks like there's no other questions. No, I'll keeping an eye for it. But otherwise, look, ladies, thank you so much. A great little session again, a little catch-up session with Tuskeen, and then obviously going through a fair bit of detail just then with Bridget. So to Tuskeen and Bridget, thank you so much for joining us today in our little lunch and learn session.
Thanks for having us, Paul.
Thank you. To all our accounting firms, look, thanks again. Look, this is for you. I know we started this last year and it's been really popular. So again, to all the firms that have got their teams also listening to this, it's a part of the ongoing learning and education we're doing, Professional Partners Education. So thanks for joining us. Just a quick little plug for my next masterclass session. So I'm talking to Jason Robinson from Future Advisory about growing pains. So they've been able to grow their firm from $1 million to $3 million in revenue. They've got big plans to take to double that again. But what are all the mistakes they've made? What can you learn from that? So that we're going to run through some positives and negatives from, we're going to run through everything. It is on the 18th of May. So if you're free from 12 o'clock on the 18th of May, please log in and secure your ticket, because that's probably just the most important thing you can do. Grab a free ticket. Let me just quick check. Oh, there is a question there that's popped up. Oh, thanks, Chris. Great session. Thanks, mate. Very sensible. Appreciate it, Chris. And the Advivo guys, we appreciate you guys being on here again. There's nothing else. I will sign off until I see you next time. Thank you, Bridget. Thank you, Tuskeen. See you next time.